Think of a familiar phrase you have heard on television, probably between the hours of 9 a.m. and 3 p.m. You hear screeching tires and a crashing sound before a voice asks, "Have you or a loved one been hurt in an auto accident?" Or perhaps there is a catchy phrase, like someone saying, "The fee is free unless you win," or "One call, that's all." Attorney advertising is ubiquitous. Hello again. I'm Professor Ron McNeil, and this is the lecture series for Ethics in the Legal Environment at the University of Mississippi. We are beginning lectures on attorney advertising and solicitation of clients. We live in an era and climate in which legal advertising is not very dissimilar from any other kind of advertising. Lawyers are on television and billboards all around. Some law firms, especially personal injury firms, have flashy advertisements with plots and jokes and jingles, and yes, some of them are outrageous and over the top. What may be surprising to some is that attorney advertising is regulated by the Bar Association, and in fact, only a few decades ago, attorney advertising was almost completely prohibited. Until the 1970s, attorneys were prohibited by ethics rules from engaging in any advertising beyond word of mouth, business cards, and putting their name in the phone book. Do people still have phone books? The prohibition on attorney advertising ended when the Supreme Court expanded First Amendment protections for commercial speech. In this lecture, we'll cover how the Supreme Court altered those protections for commercial speech, and we'll be introduced to the resulting rules for solicitation of clients. In 1977, the Supreme Court ruled in Bates v. State Bar of Arizona that Arizona's restrictive rules against attorney advertising violated the First Amendment protections for free speech. The State Bar of Arizona had almost entirely restricted attorney advertising. Bates offered low-cost legal services to people of moderate income. None of his services were big moneymakers, so he needed to accept a lot of routine matters. The best way to do that, in Bates's opinion, was to advertise the services he offered along with a schedule of the low fees at which he offered such services. The Bar Association brought a complaint against Bates because he had violated the no advertising rule. Bates challenged the complaint in court, and the case made its way to the United States Supreme Court. Justice Harry Blackmun wrote the opinion which found that commercial speech does merit First Amendment protection given the important functions it serves in society, such as providing consumers with information about services and products and helping to allocate resources in the American system of free enterprise. By classifying attorney advertising as commercial speech, the Supreme Court included it in a class of speech that has only limited protections under the Constitution. The Supreme Court doesn't consider commercial speech as highly protected as, say, literature or political speech or other speech that disseminates ideas. Because the main point of commercial speech is just garnering profit through commerce. It is not considered as sacrosanct as other subjects of speech. Based on the ruling in the Bates case, bar associations around the country have adopted a balanced approach regarding advertising. The bar is permitted, for example, to regulate attorney advertising so that it is not misleading. In the legal advertising world, we use the term puffery to describe the practice of exaggerating an attorney's skills, experience, or results in advertising. And the Bar Association is permitted to prohibit such puffery so that clients are not misled about the likelihood of success with a particular attorney. To regulate the advertisements effectively, Mississippi Rule of Professional Conduct 7.2H requires that attorneys in Mississippi submit proposed advertisements to the Bar Association for an advanced review by the bar before publishing or airing the advertisement. Lawyers who work for the Bar Association review these advertisements to make sure that they fit the requirements for legal advertising. Not all advertisements have to be reviewed. Rule 7.2 of the Mississippi Rules outline the specifics for communications that are presumed to be approved under the rules. For example, an advertisement that includes nothing more than the attorney or firm's name, address, business hours, and contact information is presumed to be okay. It is also permissible to advertise a fee for an initial consultation or advertise that you do not charge a fee for an initial consultation, as well as to publish a fee schedule like Attorney Bates attempted to do. But the rules restrict an attorney's advertising for specialties or practice areas, or the suggestion that this attorney is better than other attorneys for a particular service. A new issue in legal advertising is so-called unbundling of legal services. Before advertising, consumers were unlikely to be able to take component parts of a legal matter to more than one attorney. They hired one attorney who handled everything. Now, armed with greater knowledge of the services offered by individual attorneys, the public is capable of choosing one attorney to handle one aspect of a matter and another attorney to handle a different aspect. This has also given rise to the concept of limited scope representation, by which attorneys only offered limited services. For example, you can hire the attorney to make a court appearance or to assist in the preparation of specific documents for your case. However, when describing unbundled services, the lawyer should be clear and accurate about what fees and costs may be charged and should avoid using terms that are likely to be misleading if they cannot be substantiated. Advertising has led to changing rules about the solicitation of clients. Solicitation is an attorney's attempt to gain business, usually directed at a specific individual or group, involving an invitation to consult with the attorney regarding legal matters. In attempting to gain business, attorneys are prohibited from making false or misleading statements regarding the attorney's services. In cases in recent years where attorneys have been accused of misleading advertising, courts have questioned whether the advertising was materially misleading. Materially misleading communication is characterized by false information upon which a member of the intended audience would rely in making a decision. A statement is materially misleading if it is one upon which a person would base some or all of his decision. If it doesn't make a difference to that person, it isn't material. While some advertising is now permitted, the rules still have the traditional prohibition on what is called solicitation. One of author and attorney John Grisham's first movies is called The Firm. In one clip, Danny DeVito's character is shown guiding a new associate played by Matt Damon around the hospital as he utilizes tips from doctors and nurses to directly solicit accident victims as clients. DeVito's character tells a man in Traction that his firm is the best in Memphis and that we're going to get you a lot of money. Watch the movie if you ever get a chance, and some solicitation shall nots will become apparent. In legal advertising or in communication with potential clients, the advertisement should not present self-praise. The advertisement should not create unjustified expectations in potential clients based upon past success stories. It shouldn't offer an opinion as to the quality of the attorney's services. It surely shouldn't imply that the attorney's services are better than those of other attorneys. It shouldn't omit the name of the firm or the attorney or contain otherwise unverifiable information. Most of all, advertisements and communications are prohibited by Rule 7.1 from presenting misleading conclusions or assessments. A real-life case about misleading legal advertising is the U.S. Supreme Court case Zauderer v. Office of Disciplinary Counsel. In this case, the attorney advertised that he charged no legal fee because he was taking cases on a contingency fee basis. However, Zauderer was routinely billing his clients for costs associated with the representation when he did not win the case. So while he wasn't billing for time, he was invoicing the client for costs like filing fees or costs of investigators and experts. Was it materially misleading to advertise no legal fees, but to still invoice for costs? The Supreme Court said that it was. It is reasonable that attorneys be required to disclose information regarding the client's liability for costs. Even factual information can be misconstrued to be misleading. Disciplinary Counsel versus Shane records a complaint against a law firm that included testimonials from former clients, which the court in Ohio found to be misleading. In a per curiam opinion, the court wrote, "The commercials that contained information about the firm's past successes, while not inaccurate, were self-laudatory and inherently misleading. Despite the praises of the former clients, there is no way to objectively determine whether the results achieved by the firm were exceptional, adequate, or poor, or even whether the firm was instrumental in the outcome of the cases. Comments about past successes may create unjustified expectations of similar outcomes in the future without taking into account the peculiarities of the particular case." Now, this case is from 1998, and frankly, courts and bar associations are generally friendlier to advertisements with client testimonials now than they were 3 decades ago. There is a trend toward less restrictions on advertising. Some of the advertisements that were prohibited decades ago would probably not receive as much scrutiny today. So if this lecture seems a little confusing because it sounds like there are advertisements on television today that might not fit within the logic of a case like Disciplinary Counsel versus Shane, that's understandable. There is definitely some gray area. Key takeaways from this lecture, though, are that advertisements should not be materially misleading and that there is a foolproof way to avoid a complaint about attorney advertising, and that is to submit the advertisement to the Bar Association for prior approval. The second lecture in this unit will be a shorter lecture that covers referrals and direct solicitation of clients. Until next time.